Hello, my dear students. We are studying level of first paper, and under that paper, we are studying Industrial Dispute Act 1947. So today we will commence with this new act, the Industrial Dispute Act 1947, and under this act, which is given Unit 3 of labor law first paper, we will cover industrial dispute and individual dispute. We will also talk about the arena of interaction and participants, industry, workmen, and employer. So first we talk about the industrial dispute and individual dispute. Now the question is, can an individual dispute become an industrial dispute? Before the introduction of Section 2A of the Act, an individual dispute could not in itself be an industrial dispute, but it could become once if the trade union or a number of members had been involved. The Supreme Court and the majority of industrial tribunals held that a dispute raised by a dismissed employee would not be treated as an industrial dispute unless it is supported by a trade union or by a body or section of workmen. So if there is a dispute and which is raised by the dismissed employee, and it will not be treated as an industrial dispute unless it is supported by a trade union or by a body or section of a work. So the Supreme Court and the majority of the industrial tribunals held this thing. And in a landmark case of Workmen of Democratic State versus the Management of Democratic State, Supreme Court identified two tests to determine whether a dispute was industrial or individual. So in this case, Supreme Court identified these two tests, with the help of which we can determine whether a dispute was industrial or it was an individual dispute. And these tests are: number one, a real dispute that can be resolved by relief from one party to another. And number two, the person for whom the dispute arises must be one in whose employment, non-employment, working conditions the parties to the dispute have a direct or substantial interest, and these must depend on the facts and circumstances of each case. So what are the two tests? The test number one is a real dispute that can be resolved by relief from one party to another, and the person for whom the dispute arises must be one in whose employment, non-employment, working conditions the parties to the dispute have a direct or substantial interest, and this must depend on the facts and circumstance of each case. And Section 2A does not state that all individual disputes are industrial disputes. It is only when a dispute relates to a discharge, dismissal, retrenched, or terminated worker that it is treated as an industrial dispute. So Section 2A does not state that all individual disputes are industrial disputes. It is only when a dispute relates to discharge, dismissal, retrench, or a terminated worker, and it is treated as an industrial dispute. And if the dispute or difference relates to some other matter, for example, the payment of a bonus, or it is related to the gratuity payment maybe, then the task laid down in the court decisions would have to be met. And now we will just have a quick look of what is the difference between industrial dispute and the individual dispute. Industrial dispute given under section 2K of the Industrial Dispute Act 1947, which says industrial dispute means any dispute or difference between the employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment, or the terms of the employment, or with the conditions of labor of any person. So industrial dispute means dispute or difference between employer and employer, or between employer and workman, or between workman and workman, and which is connected with the employment or non-employment, or the terms of the employment, or with the conditions of labor of any person. Now we just see that so far the industrial disputes are concerned, they are more collective in nature, while the individual disputes are the individual disputes. Union alone can raise a dispute in case of industrial dispute, while in case of individual dispute, only workman can raise the dispute. In case of industrial dispute, it must be referred by the government, while in case of individual dispute, no reference required. And in case of industrial dispute regarding any dispute, and in case of individual dispute, it can be only to the limited issues. Now, conditions under which an individual dispute becomes an industrial dispute, Supreme Court held that an individual dispute could be transformed into an industrial dispute if it was sponsored by a trade union, or if it was sponsored by a significant number of workers. In order to make an individual dispute into an industrial dispute, it must be taken up by the union of employees of the establishment, and where no such union exists, it can be married by any union of workers employed in similar trade. With regard to the second condition, if an individual dispute between a worker is dealt with the considerable number of workers of the same establishment, it becomes an industrial dispute. The court admitted that the term number appreciable does not mean a majority of the workers. We would like to go for a glimpse of definition of industry also given under the ID Act here. The section under section 2J of the Industrial Dispute Act 1947, this section defines the industry means any business, trade, undertaking, manufacturing, or calling of employers, and any calling for service, employment, handicraft, or industrial occupation, or vocation of workmen. The main participants in the industrial relations are the employers have their association to deal with labor problems and their unions in collective way. Workers are represented by their trade unions. So the main participant in the industrial relations are the employers, the workers, the association of employers, the trade unions also. And government tries to regulate the relation between the two, employees and employers, by implementing labor laws. So far the definition of workman is concerned under section 2S of the ID Act 1947, workman means any person including an apprentice employed. So workman means any person, which includes an apprentice also, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire of reward, for hire or reward, whether the terms of the employment be express or implied, and for the purposes of any proceeding under this act in relation to an industrial dispute. So workman means any person, and this definition includes the apprentice also, employed in an industry to do any manual and skilled technical operation, clerical or supervisory work for hire or reward, whether the terms of the employment be express or implied, and for the purpose of any proceedings under this act in relation to industrial dispute, and includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchments has led to that dispute, but does not include any such person who is subject to the Air Force Act 1950 or the Army Act 1950. Sections are given 45, 46, or the Navy Act 62 of 1950, section 62 of 1957, who is employed in police service as an officer or other will not be included under the definition of the workman given for under this act, ID at 1947, Industrial Dispute Act 1947, and who is employed mainly in managerial or administrative capacity will not be included under the definition of workman, and who being employed in a supervisory capacity draws wages exceeding 1,600 rupees as per mentioned exercise, otherwise the nature of the duties. So these are certain classes which are not included in the workman definition given under the act. And under section 2G, the definition of the employer is given. Employer means in relation to an industry carried on by or under the authority of an department of the central government or the state government, the authority prescribed in this behalf, or where no authority is prescribed, the head of department, in relation to an industry carried on by or on behalf of the local authority, the chief executive officer of that authority. And as we have already discussed the definition of industrial dispute given under section 2K, that in industrial dispute means any dispute or difference between employer-employer and employer between employer and employer, and between employers and workmen, or between workmen and workmen, which is connected with the employment, non-employment, or the terms of the employment, or with the conditions of labor of any person. So this is the definition given under section 2K of the ID Act 1947. So these are certain definition of workman, definition of employer given under section for the purpose of this ID Act 1947, definition of industry given under section 2J, and when an individual dispute will be treated as a industrial dispute, and what is the difference between industrial dispute and the individual dispute. So this is, and we have also gone through that how these industry, workmen and employer are the participants so far the industrial relations are concerned, and these are the main constituents of the industrial relation. So my dear student, this is all for today's lecture. I believe this lecture will help you, and you just go through the definitions, and as I usually advise you that whenever you are just going through these PPTs notes, kindly have a look of the Bare Act also. If you have any confusion, any doubt, take help of the Bare Act also. So this is all for today's lecture. Thank you so much, and in our next lecture we will take up the new topic under the ID Act 1947. Thank you so much, and